Hello, everyone. D. Wilmore, head of brokerage here at Radius. In this session, what we're going to be talking about is liquidated damages. Now, we've talked quite a bit in earlier sessions about liquidated damages. To be very specific, very clear about liquidated damages exist when a buyer is in breach on a purchase agreement. In other words, that means that they've defaulted on the agreement to purchase the home. They've removed all of their contingencies. They've gone a certain distance in the contract, and then for whatever reason, they decide they no longer want to move forward with the sale of this property. So let's do that. Hello, everyone. D. Wilmore, head of brokerage here at Radius. In this session, what we're going to be talking about is liquidated damages. We've talked in earlier sessions about liquidated damages. What is liquidated damages? Liquidated damages is when a buyer fails to complete the purchase because the buyer defaulted. In other words, the buyer removed all of their contingencies, and for whatever reason, they've decided not to move forward with the purchase of the property. Because it's a legal and binding contract, the seller or the buyer is said to be in default, and the seller is stating that they've been damaged by the fact that the buyer won't move forward. So the monies that the buyer put up as a deposit, earlier when we talked about initial deposit, usually 3% of the purchase price, that's the buyer expressing, Mr. and Mrs. Seller, I love your house so much, I wish to purchase it, and I'm so serious about it, I'm going to give you money in advance to show you that I'm serious about moving forward. So liquidated damages is taking that deposit that has been forwarded by the buyer and paying it to the seller for compensation for damage. That's what's known as liquidated damages. And typically liquidated damages is 3% of the purchase price or the deposit, or whichever one is greater. But typically no more than 3% of the purchase price can be expressed as liquidated damages. Each party, the buyer and the seller, has to agree on how those funds are going to be released. It's required that there's mutual, because there could have been things that have happened on the seller side that caused the buyer not to move forward. So liquidated damages is not an automatic. Typically, it's adjudicated. In other words, a lawyer, usually with 7 years or more of experience, or a judge, is the person who is actually conducting an arbitration to discuss how this money is going to be conveyed to the seller, if it's going to be conveyed to the seller at all. But liquidated damages is all about a buyer in breach and that deposit being forwarded to the seller as compensation for damage. We talked a bit about how does that happen. So before liquidated damages ever comes into play, typically the buyer and the seller are agreeing to what's called mediation. Mediation is where both parties are saying, if we have a dispute as a result of this transaction, we both agree to come together and see if we can work something out in advance before any other legal action takes place, okay? Because of course, arbitration and any other further legal matters can be expensive. So each party is going to agree to come together to see if they can provide a mutual decision as to what's going to happen, how they're going to move forward before any other further legal action takes place, okay? And then finally, if they can't agree on how to move this thing forward, each party will go to what's called arbitration. Again, arbitration is where they're hiring an adjudicator, usually an attorney with 5 or more years of residential real estate law experience, to make the decision for them. And both of them agree to abide by the decision of the arbiter. Okay, there are a few exclusions that happen in that matter, but as you're explaining this to your buyer client, you want to make it known. You want to be very specific. Mr. and Mrs. Buyer, you are entering into a legal, bilateral, binding contract with the seller. Should at any point after you've released all of your contingencies that you decide you don't want to purchase, you run the risk of losing your deposit. Do you understand that, Mr. or Mrs. Buyer? Okay. And you're going to have them acknowledge that by initialing here at this bottom section in line item 31. They'll be signing to the fact of you to advise them that they may lose their deposit should they be in breach after the removal of their contingencies. Okay? So that's liquidated damages, mediation, and arbitration. When we talk about the buyer's offer is a signatory page to where the buyer is signing and saying, I'm making this purchase. This is my signature. This is how I'm going to move forward. All buyers need to sign section 32, where that's the buyer signatory page. And then the acceptance would happen from the seller. The seller would then sign their section that says, yes, I'm the one who was going to buy this, to accept this offer. And I warrant that I'm not in contract with anybody else, and all the above, which would be line item 33. And that would be a complete contract. Okay? As always, guys, I appreciate your participation, and I will see you in the next session.